Hello everyone. My name is Sampa Karmkar Singh. I am Assistant Professor at WBNEJS Kolkata. Today we are going to discuss about one very important topic, that is right to information. Democracy is the government of the people, for the people, by the people. It is a famous quote by Abraham Lincoln. The Constitution of India has established a democratic republic. Democracy requires an informed citizen and transparency of information, which are vital to its functioning and to hold governments and their instrumentalities accountable to the governed. The revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the government, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. Now let us concentrate about what is right to information. It is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. It is expedient to provide for furnishing certain information to citizens who desire to have it. This paved the way for the enactment of the Right to Information Act, and this act came in 2005. Right to information opens up the government's record to public scrutiny. The basic object of the Right to Information Act is to empower the citizens to promote transparency and accountability in the working of the government, to contain corruption, and to enhance people's participation in the democratic process, thereby making our democracy work for the people in a real sense. This act also brings information to the citizen. The Right to Information Act 2005 mandates a timely response to citizens' requests for government information. It is an initiative taken by Department of Personnel and Training, Ministry of Personnel, Public Grievances and Pensions to provide a RTI portal gateway to the citizens for quick search of information on the details of first appellate authorities, PIOs, PIO means Public Information Officers, etc., amongst others. Besides access to RTI, that is right to information, related information or disclosures published on the web by various public authorities under the Government of India as well as the state government. Coming to the definition of right to information, it is provided under Section 2J of this Act. Right to information means the right to information accessible under this Act, which is held by or under the control of any public authority. Here, please concentrate that it is about only any public authority and includes the right to inspection of work, documents, records, taking notes, extracts, or certified copies of documents or records, taking certified samples of material, obtaining information in the form of diskettes, floppies, tapes, video cassettes, or in any other electronic mode or through printouts where such information is stored in a computer or in any other device. Right to Information Act also provides the definition of information under Section 2F. It means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. Coming to another definition, Section 2H defines public authority. It means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by the Parliament, by any other law made by state legislature, by notification issued or order made by the appropriate government. It also includes any body owned, controlled, or substantially financed or NGOs substantially financed directly or indirectly by funds provided by the appropriate government. Section 8 is very interesting and very important provision of this enactment. It talks about exemption from disclosure of information. It provides information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. Second, information which has been expressly forbidden to be published by any court of law or tribunal or the disclosure of which may constitute contempt of court. C. Information, the disclosure of which would cause a breach of privilege of parliament or the state legislature. D. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. E. Information available to a person in his fiduciary relationship unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. Information received in confidence from foreign government. Information the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. H. Information which would impede the process of investigation or apprehension or prosecution of offenders. Cabinet papers, including records of deliberations of the Council of Ministers, Secretaries, and other officers, provided that the decision of Council of Ministers, the reasons, and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. Those matters which come under the exemptions specified in this section shall not be disclosed. So, this is exemption from disclosure. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest or which would cause unwarranted invasion of the privacy of the individual unless the Central Public Information Officer, that is CPIO, or the State Public Information Officer, SPIO, or the appellate authority, as the case may be, is satisfied that the larger public interest justifies the disclosure of such information. The information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. A public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. Under the Right to Information Act, the public interest test in Section 8, subsection 2 requires public authorities to disclose information even if it falls under an exemption if the public interest in disclosure outweighs the harm to the protected interest. This means that even if the information is normally exempt, it must be disclosed if the public benefit of transparency and accountability outweighs the potential harm. Let me tell you about one very important case in this regard. Justice K.S. Puttaswamy versus Union of India. AIR 2018. This is a Supreme Court judgment. This case is also popularly known as the right to privacy case. If you just give a Google search to right to privacy case, this case will come up. Right to privacy is a fundamental right protected by our Indian Constitution. This decision affirms that individuals have a constitutional right to privacy, which is an essential part of their right to life and personal liberty, which is enshrined under Article 21 of our Indian Constitution. One recent enactment, that is the Digital Personal Data Protection Act 2023. This is popularly known as, the short form is DPDP Act. You might have heard of this legislation. It's a very new enactment which came just in 2023. With changing times, everything has gone digital. This act provides for the processing of digital personal data in a manner that recognizes both the right of individuals to protect their personal data and the need to process such personal data for lawful purposes. The DPDP Act 2023 is India's first comprehensive data privacy law, enacted in August 2023. This act aimed at regulating the collection, storage, and sharing of digital personal data. Section 2H of this enactment, it provides the definition of data. Data means a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation, or processing by human beings or by automated means. Section 2N talks about digital personal data means personal data in digital form. Section 2T provides personal data. It means any data about an individual who is identifiable by or in relation to such data. Section 2Y, this is very interesting provision. It defines C. C in relation to an individual includes the reference to such individual irrespective of gender. There are few illustrations also which has been provided. The first illustration is X, an individual, while blogging her views, has publicly made available her personal data on social media. In such case, the provisions of this act shall not apply. The second illustration says X, a pregnant woman, enrolls herself on an app or website to avail of government's maternity benefit program. While consenting to provide her personal data for the purpose of availing of such benefits, government may process the personal data of X processing to determine her eligibility to receive any other prescribed benefit from the government. Illustration 3 is X, an individual, registers herself on an online marketplace operated by Y, an e-commerce service provider. X gives her consent to Y for the processing of her personal data for selling her used car. The online marketplace helps conclude the sale. Y shall no longer retain her personal data. So once it's concluded, the sale is confirmed. After that, Y shall no longer retain the personal data of X. The last illustration is X, an individual, takes a loan from Y, a bank. X defaults in paying her monthly loan repayment installment on the date on which it falls due. Y may process the personal data of X for ascertaining her financial information, assets, and liabilities. Now, there is very interesting provision which is included in this act, that is the breach of provision and penalty. So, breach in observing the obligation of data fiduciary to take reasonable security safeguards to prevent personal data breach. Penalty may be extended to 250 crore rupees. So, you can see that the penalty is very huge. Second is breach in observing to give the board or affected data principal notice of a personal data breach. Penalty may extend to 200 crore rupees. Breach in observance of additional obligations in relation to children. Penalty may extend to 200 crore rupees. Breach in observance of additional obligations of significant data fiduciary. Here the penalty may extend to 150 crore rupees. Breach in observance of the duties. Penalty may extend to 10,000 rupees. Breach of any term of voluntary undertaking accepted by the board up to the extent applicable for the breach in respect of which the proceedings under Section 28 were instituted. Breach of any other provision of this Act or the rules, here the penalty may extend to 50 crore rupees. So, the Act has been designed in such a way to provide huge penalty if any provision is breached. Coming to this important concept, the RTI versus DPDP. Currently, there is a debate which is ongoing on the Section 44, subsection 3 of the DPDP Act, and it is alleged that it weakens the Right to Information Act 2005. The reason is that this section amends Section 81J of the RTI Act. It prohibits the sharing of all personal information. Section 81J of the RTI Act entails exemption from disclosure of personal information unless it is of public interest. But DPDP Act has prohibited the sharing of all personal information. So the debate is still ongoing. Section 9 of the Right to Information Act talks about the grounds for rejection to access in certain cases. A central public information officer or a state public information officer may reject a request for information where such a request for providing access would involve an infringement of copyright subsisting in a person other than the state. Section 11 is very interesting provision. It talks about third party information where a central public information officer or a state public information officer intends to disclose any information or record on a request made under this Act which relates to or has been supplied by a third party and has been treated as confidential by that third party. The central public information officer or the state public information officer, as the case may be, shall, within 5 days from the receipt of such request, give a written notice to such third party of the request and of the fact that it intends to disclose the information or record, and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed, and such submission of the third party shall be kept in view while taking a decision about disclosure of information, provided that except in the cases of trade or commercial secrets protected by law, disclosure may be allowed if the public interest in disclosure outweighs in importance any possible harm or injury to the interest of such third party. One case reference here is of R.K. Jain versus Union of India. This case came in 2013. The performance of an employee or officer in an organization is primarily a matter between the employee and the employer, and normally those aspects are governed by the service rules which fall under the expression personal information, the disclosure of which has no relationship to any public activity or public interest. On the other hand, the disclosure of which would cause unwarranted invasion of privacy of that individual. Of course, in a given case, if the central public information officer or the state public information officer or the appellate authority is satisfied that the larger public interest justifies the disclosure of such information, appropriate orders could be passed, but the petitioner cannot claim those details as a matter of right. Coming to one very interesting part, that is about the notice, where a notice is served by the central public information officer or state public information officer to the third party, then the third party shall within 10 days from the date of receipt of such notice be given the opportunity to make representation against the proposed disclosure. The CPIO or SPIO shall, within 40 days after receipt of such request, if the third party has been given an opportunity to make representation, make a decision as to whether or not to disclose the information and give in writing the notice of his decision to the third party. The notice shall include a statement that the third party to whom the notice is given is entitled to prefer an appeal under Section 19 against the decision. Section 12 talks about the Central Information Commission. The central government shall, by notification in the official gazette, constitute a body to be known as the Central Information Commission to exercise the powers conferred on and to perform the functions assigned to it under this Act. It shall consist of the Chief Information Commissioner and such number of Central Information Commissioners not exceeding 10 as may be deemed necessary. Appointed by committee, the Chief Information Commissioner and Information Commissioners shall be appointed by the President on the recommendation of a committee, and this committee is consisting of the Prime Minister, the Leader of Opposition, a Union Cabinet Minister to be nominated by the Prime Minister. The qualification, the Chief Information Commissioner and the Information Commissioners shall be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, or administration and governance. The Chief Information Commissioner or an Information Commissioner shall not be a member of Parliament or member of the legislature of any state or union territory, or hold any other office of profit or connected with any political party or carrying on any business or pursuing any profession. Headquarters of the Central Information Commission. The headquarters of the Central Information Commission shall be at Delhi, and the Central Information Commission may, with the previous approval of the central government, establish offices at other places in India. Term of office and conditions of service. The Chief Information Commissioner shall hold office for a term of 5 years from the date on which he enters upon his office and shall not be eligible for reappointment, provided that no Chief Information Commissioner shall hold office as such after he has attained the age of 65 years. Every Information Commissioner shall hold office for a term of 5 years from the date on which he enters upon his office or till he attains the age of 65 years, whichever is earlier, and shall not be eligible for reappointment as such Information Commissioner. RTI Amendment Act 2019. The Right to Information Amendment Act 2019 primarily focused on altering the terms and conditions of employment for Information Commissioners at both the central and state levels. Specifically, interesting fact about the Information Commissioner. Every Information Commissioner shall, on vacating his office, be eligible for appointment as the Chief Information Commissioner in the manner specified under the Act. Where the Information Commissioner is appointed as the Chief Information Commissioner, his term of office shall not be more than 5 years in aggregate as the Information Commissioner and the Chief Information Commissioner. He may resign and he may be removed. The Chief Information Commissioner or an Information Commissioner may, at any time, by writing under his hand, address to the President, resign from his office if he wishes, provided that the Chief Information Commissioner or an Information Commissioner may be removed in the manner which is specified in Section 14 of this Act. Now coming to Section 14, the Chief Information Commissioner or any Information Commissioner shall be removed from his office only by order of the President on the ground of proved misbehavior or incapacity after the Supreme Court, on a reference made to it by the President, has on inquiry reported that the Chief Information Commissioner or any Information Commissioner ought on such grounds be removed. Guilty of misbehavior. If the Chief Information Commissioner or a Information Commissioner in any way concerned or interested in any contract or agreement made by or on behalf of the Government of India or participates in any way in the profit thereof or in any benefit or emolument arising therefrom, otherwise than as a member and in common with the other members of an incorporated company, he shall, for the purposes of subsection 1 of section 14, be deemed to be guilty of misbehavior. So this is the checklist how you will determine that the person is guilty of misbehavior. The President may by order remove from office the Chief Information Commissioner or any Information Commissioner if that person is adjudged an insolvent or has been convicted of an offense which is, in opinion of the President, involves moral turpitude or engages during his term of office in any paid employment outside the duties of his office, or is, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body, or has acquired such financial or other interest as is likely to affect prejudicially his functions as the Chief Information Commissioner or a Information Commissioner. Section 15 talks about the State Information Commissioner. Every state government shall, by notification in the official gazette, constitute a body to be known as the, and here the dot is for mentioning the name of the state, Information Commission, to exercise the powers conferred on and to perform the functions assigned to it under this Act. The State Information Commission shall consist of a state chief information commissioner and such number of state information commissioners not exceeding 10 as may be deemed necessary. Appointment. The state chief information commissioner and the state information commissioners shall be appointed by the governor on the recommendation of a committee consisting of the chief minister, who shall be the chairperson of the committee, the leader of opposition in the legislative assembly, and a cabinet minister to be nominated by the chief minister. The qualifications is that for the state chief information commissioner and the state information commissioners shall be person of eminence in public life with wide knowledge and expertise in law, science and technology, social service, management, journalism, mass media or administration and governance. The state chief information commissioner or a state information commissioner shall not be a member of parliament or member of the legislature of any state or union territory, or hold any other office of profit or connected with any political party or carrying on any business or pursuing any profession. The headquarters. The headquarters of the State Information Commission shall be at such place in the state as the state government may, by notification in the official gazette, specify, and the State Information Commission may, with the previous approval of the state government, establish offices at other places in the state. The term of office and conditions of service. The State Chief Information Commissioner shall hold office for a term of 5 years from the date on which he enters upon his office and shall not be eligible for reappointment, provided that no State Chief Information Commissioner shall hold office as such after he has attained the age of 65 years. Section 17 talks about removal of State Chief Information Commissioner or State Information Commissioner. The State Chief Information Commissioner or a State Information Commissioner shall be removed from his office only by order of the Governor on the ground of proved misbehavior or incapacity after the Supreme Court, on a reference made to it by the Governor, has an inquiry reported that the State Chief Information Commissioner or a State Information Commissioner ought on such ground be removed. Other grounds are same as discussed under Section 14 of this enactment. Same power as are vested in a civil code. This is very important and interesting. The Central Information Commission or State Information Commission shall, while inquiring into any matter under this section, they have the same powers as are vested in a civil code, while trying a suit under the Code of Civil Procedure, that is CPC, in respect of the following matters. The first is summoning and enforcing the attendance of persons and compel them to give oral or written evidence on oath and to produce the documents or things, requiring the discovery and inspection of documents, receiving evidence on affidavit, requisitioning any public record or copies thereof from any court or office, issuing summons for examination of witnesses or documents, and any other matter which may be prescribed. Now coming to the appeal provision. Any person who does not receive a decision within the time specified or is aggrieved by a decision of the Central Public Information Officer or State Public Information Officer, as the case may be, may within 30 days from the expiry of such period or from the receipt of such a decision prefer an appeal to such officer who is senior in rank to the Central Public Information Officer or State Public Information Officer as the case may be in each public authority, provided that such officer may admit the appeal after the expiry of a period of 30 days if he or she is satisfied that the appellant was prevented by sufficient cause from filing the appeal in time. So this is about the condonation of delay. Penalties. Where the Central Information Commission or the State Information Commission at the time of deciding any complaint or appeal is of the opinion that the Central Public Information Officer or the State Public Information Officer has, without any reasonable cause, refused to receive an application for information or has not furnished information within the time which is specified or malafidely denied the request for information or knowingly given incorrect, incomplete, or misleading information or destroyed information which was the subject of the request or obstructed in any manner in furnishing the information, it shall impose a penalty of 250 rupees each day till application is received or information is furnished. So, however, the total amount of such penalty shall not exceed 25,000 rupees. Reasonable opportunity of being heard. This is also known as audi alteram partem, and this is a rule of natural justice. It provides that the Central Public Information Officer or the State Public Information Officer shall be given a reasonable opportunity of being heard before the penalty is imposed on him, provided further that the burden of proving that he acted reasonably and diligently shall be on the Central Public Information Officer or the State Public Information Officer as the case may be, provided further that the burden of proving that he acted reasonably and diligently shall be on the Central Public Information Officer or the State Public Information Officer as the case may be. Section 21 talks about the protection of action which is taken in good faith. No suit, prosecution, or other legal proceeding shall lie against any person for anything which is in good faith done or intended to be done under this Act or any rule made thereunder. Section 24 talks about Act not to apply to certain organizations. Nothing contained in this Act shall apply to the intelligence and security organizations which are specified in second schedule of this Act, being organizations established by the central government or any information furnished by such organizations to that government. Section 24 also provides one proviso which says that the information pertaining to the allegations of corruption and human rights violations shall not be excluded, provided further that in the case of information sought for is in respect of allegations of violation of human rights, the information shall only be provided after the approval of the Central Information Commission, and such information shall be provided within 45 days from the date of the receipt of such request. Coming to RTI online portal. In the RTI online portal, you can get all your queries answered which is related to right to information, and they have a very updated online portal. How to obtain information under the RTI Act of 2005. This is the procedure which an applicant has to follow if he or she wants to obtain any information under this enactment. An applicant who desires to obtain information under the RTI Act can make a request through the RTI online portal to the central ministries, departments, and other central public authorities mentioned in online RTI request form. Next question is how to fill out the RTI request form. The text of the application may be written in the prescribed column of the RTI request form. At present, the text of the application is confined up to 3000 characters only. In case the text of an application contains more than 3000 characters, in that case, it can be uploaded as a PDF attachment in the supporting document column of that form. How to pay RTI fee? After filing the first page of the RTI request form, a non-BPL applicant has to click on Make Payment button for payment of the prescribed RTI fee. The applicant can pay the prescribed RTI fee through the following modes. First is internet banking through SBI Payment Gateway and its associated banks. Second is using ATM cum debit card of State Bank of India. Third is credit or debit card of Master or Visa card. Fourth is UPI. No fees for BPL. BPL means below poverty line. It may be noted that no RTI fee is required to be paid by a citizen who is below poverty line as per the RTI rules of 2012. However, the BPL applicant must attach a copy of the certificate issued by the appropriate government in this regard, along with the application. Unique registration number for future reference. On submission of an application, a unique registration number will be issued which may be referred by the applicant for any future reference. It may be noted that the application filed through this RTI online portal will reach electronically to the nodal officer of the state ministry or department and not to the CPIO of the concerned ministry or department. The nodal officer will transmit the RTI application electronically to the concerned CPIO. What happens if the wrong public authority is selected by the applicant? In case the RTI application is not meant for the public authority which has been selected by the applicant, the nodal officer of the state public authority will transfer the application electronically to the nodal officer of the concerned CPIO if aligned to this portal, and physically to that central public authority which is not aligned to the online portal. Under Section 6, Subsection 3 of the RTI Act, it may be noted that RTI applications filed through the online portal for the state public authorities including NCT of Delhi would be returned without any refund of fees. Additional fee if required. In case additional fee representing the cost is required for providing information, the CPIO will intimate the same, which can be viewed by the applicant through View Status option in the RTI online portal, and an email alert or SMS or both will also be sent to the applicant for the same. For payment of additional fee online, the applicant needs to use the option View Status in the RTI online portal, and on providing the registration number of the request, option for make payment will be available. How to file the first appeal? For making an appeal to the first appellate authority, the applicant has to select the option Submit First Appeal in the RTI online portal and fill up the form that will appear. The registration number and email ID of the original application is required for filing the first appeal. As per the RTI Act, no fee has to be paid for first appeal. Though optional, the mobile number can be provided by the appellant in order to receive SMS alerts. Don't panic if you forget your RTI credentials. It is possible that you forget your RTI credentials. You can go to the View History column to see your past RTI requests and appeals. Is it mandatory to create user account? No. It is not mandatory to create user account on RTI online web portal. You can directly file your RTI on Submit Request tab. For how much time RTI request or appeal retain at the online portal? In the View History or View Status, you can see RTI cases retained for a period of 3 years. What should you do if amount is deducted from your account but registration number is not generated? Remember, you should not attempt to make payment repeatedly or try to submit request once again. Kindly wait for 24 to 48 working hours as registration number will be generated after reconciliation. If it is not generated within stipulated time frame, then kindly send an email to help@rtionline.dopt@nic.in with your transaction details. What if the registration number is not received on your email or mobile number even after 48 working hours? So registration numbers are generated after reconciliation of bank scrolls for cases whose numbers are not generated instantly after the payment. This procedure may take 24 to 48 working hours. If someone still does not receive the registration number, they may contact their respective bank for refund of amount. What if the online portal is not allowing you to file the first appeal? This may happen under two circumstances. First is when your RTI application has been physically transferred to other public authority which is not aligned to this portal. In such a case, you are required to file your appeal in physical mode to the concerned public authority. Second situation is if your RTI application has not been replied to by CPIO and 30 days period has not lapsed. In such a case, you may file first appeal only after completion of the stipulated time period of 30 days. Can you file online first appeal for any RTI application which is filed physically in the first place? The answer is no. Online first appeal can only be filed against previously filed online RTI application when the RTI application file is not reflecting in the user account history. If you have opted to file RTI or first appeal directly, that is without logging into your user account, then in such cases you will not be able to see the filed RTI or appeal in your registered account history. However, you can always check its status in view status with the provided registration numbers. When multiple RTI registration numbers even though you have filed a single RTI application. This is the case where in your RTI application has been forwarded to multiple CPIOs since the information sought lies more than one PIO. How can you view status or reply of your RTI application or first appeal? The answer is status or reply of the RTI application or first appeal which is filed online can be viewed by the applicant by clicking on view status. How to upload a supporting document if an alert comes as supporting documents required from applicant. When a public authority requests for supporting document, an alert is sent to the applicant to his or her mobile or email ID. In such situation, the applicant is requested to visit the RTI online website and enter the details in view status. Once the detail is entered, the current status of the RTI application is shown along with the option for uploading the supporting document. What queries can be raised with helpline email, that is help@rtionline.dopt@nic.in. Helpline email ID is exclusively meant for queries or problems being faced while filing the online RTI through the online portal. Please do not send mail to this helpline for any other matter or asking for any other details. The reply is limited to RTI online portal of central government only. What to do when the browser shows a certificate error while opening the RTI online portal? You should ignore the certificate error and proceed forward. Don't distract and kindly select Mozilla Firefox, that is, I understand the risk, add exception, Google Chrome, proceed anyway, Internet Explorer, continue to this website. Reasons behind RTI payment failure. The major reasons for failure are due to business declines are as under. First is customer has set e-commerce flag as disabled for debit credit card. Second is customer either closed the internet browser or not proceeded further with the transaction resulting into session timeout. Third is wrong OTP or no OTP entered by customer. Last is wrong details of cards entered by customer like card number, CVV and expiry date. Then insufficient balance in customer's account. Customer cancelled the transaction and reinitiated with different mode of payment, say from debit card to UPI, etc. Customer received collect request for payment in UPI app but not completed the payment within time limit. Why OTP feature is introduced in view status option. RTI application may contain personal information of the applicant, and if any third person gets the registration number and email ID, then the person can view this personal information. So, in order to protect personal information of the applicant, according to cybersecurity norms, the OTP validating feature has been introduced. OTPs do not expire until they are used. This is again very interesting feature. In view status option, while OTPs are promptly dispatched from the NIC email domain, delays may occasionally occur due to high traffic on either NIC server or external email services like Gmail or Yahoo. Importantly, OTPs do not expire until they are used. meaning users can access the status of their applications as soon as the OTP arrives. Coming to the concluding remarks, the basic object of the RTI is to empower the citizens, promote transparency and accountability in the working of the government, contain corruption, and make our democracy work for the people in a real sense. It goes without saying that an informed citizen is better equipped to keep a necessary vigil on the instruments of governance and make the government more accountable to the governed. The RTI Act is a big step, a huge step towards informing citizens about the activities of the government. Now, coming to a few questions. Question number one. Applications for information under the RTI 2005 can also be submitted to completely privately owned organizations. The answer option is false, true, only if the information does not pertain to their accounts and finances. Last option is only if they are registered in another country. The answer is false. Question number two. Which provision of the RTI Act discusses third party information? Options are Section 10, Section 12, Section 11. The last option is none of the above. The correct answer is Section number 11, which is provided in option number 3. The RTI Act gives right to seek information from the following. First option is private companies, second is MNCs, that is multinational companies, third is public authorities, last one is associations. The correct answer is public authorities. Thank you for the patient hearing. I hope that this presentation will help you to know more about right to information, which is a cherished feature of our constitution under Article 21 of our Indian Constitution, and also it has helped you to know and explore more about the RTI through the RTI online portal. Thank you so much.